We're now at the point in the draft, when Roger Goodell or Adam Silver, they've done their portion and they hand it off to one of their other deputy commissioners. That's me right now. Have an honor of introducing Jamie Brackin, though. Jamie has a very impressive legal CV, having done stuff in Summit County, Wyoming, being an attorney, a teacher, everything in between. But what's really cool is that in her pre-law life, Jamie worked in Hollywood for many years as a celebrity coordinator for the game show company Mark Goodson Productions, booking celebrities for game shows like Password, Hollywood Squares, Match Game, Family Feud. Was this in the Richard Dawson days? Did you have to kiss him on the mouth? Nice. She has many stories from those days. She now resides in St. George and is thankful that she does not have to shovel snow like we did in Harriman this morning. I also have it on good authority that Jamie was entertainment on cruise ships for some time as well. No? Marilyn, did you make that up? Yes. Okay. But we'll turn the time over to Jamie. Jamie, thank you for being here. Appreciate you.
Thank you for letting me come once again. It's always flattering to be invited back. It's like the worst time slot though, right? You guys just ate lunch, you're ready to fall asleep. It's like, I'll try to keep it somewhat entertaining, but I won't be offended if y'all snooze on me. I may pick on you though. Once again, we're back with my ABCs of the legislative session. This focuses on the legislative bills that were passed that deal with civil issues in government. I am a civil attorney. I'm deputy city attorney now for the city of St. George, and he's right. I do not miss the snow. When I drove up last night and saw snow, I went, oh yeah, that. It's been really, really nice not to have to shovel anymore. But it was an interesting year. It was an interesting legislative year for anybody who tracked it. I was so motivated this year that I was going to be on top of every bill file as it came in. I was going to take notes. I was going to be prepared. Yeah. And then I saw how many bill files there were. This was like, I think, the most bill files we've had in a legislative session. There were over 2,000 bills to try to keep track of. And of those, 582 passed. Very interesting session. However, I think if I'm going to pick a letter of the year, it's going to be the letter R. Well, wait a minute, I'm going to go back. So last year, just to compare, was only 2,060, but we passed more bills, or the legislature did, not me. 2023, that gives you a comparison. And in the the last pre-COVID session, you can see it was only 1,600 bills. So again, there were a lot of freshman legislators, lots and lots and lots of bills. There was rumor that they were going to limit, that leadership was going to limit how many bill files each legislator could open, but that didn't happen. So anyway, again, going back to the letter of the year, it's R. For revenge, retaliation, retribution, whatever you want to call it. It was really interesting to watch what happened because after last year's legislative session and some things going on, leadership in the House and the Senate really shook things up, and the people that went against leadership are no longer sitting as committee chairs. They got removed. There were committee shakeups, and so you had a lot of new faces and a lot of new makeups on some of the committees. There were a lot of bills aimed at the courts, especially the Supreme Court, because they didn't like the rulings that the Supreme Court came out with. I don't know if you followed, Brady Brammer had several bills that were just like really aimed at the courts. And they were mad. They were mad that they got smacked down. I know the feeling. This one was also a Brammer bill, this one that removed the attorney privilege and the attorney work product protections for legislative audits. Very interesting, very interesting. We'll talk about that one a little bit later. But just out of curiosity, in terms of the civil stuff, when you deal with like water and elections and taxes and land use and housing and all that kind of stuff, anybody want to guess what the #1 category was this year for the most bills? Housing? Well, you're up there. So there were 13 water bills, 16 election bills, there were 24 tax bills, and 25 housing and land use bills. That's a lot. We'll try to get through most of this, but we'll go on to the alphabet. All right, here we go. You awake with me still? So far, so good? Okay. A this year is for the attorney work product privilege, attorney privilege and attorney work product privilege. Again, there was an audit that the state legislative auditors did, and I think it was with regard to the former attorney general, and there were some documents that weren't produced, and the legislature got mad, and so they passed a bill that says that privilege no longer exists, and attorneys have to turn over attorney work product, all your notes, all your drafts, if there's a legislative audit. Anybody like that one? I hate it. I think it's ridiculous. I don't know where this is going to go. I don't know what kind of challenges we're going to have. But, they reiterated that the privilege exists for everybody else except the legislature and a legislative audit. Senate Bill 96 is not in your packet, but I wanted to, we talked about this one last year about the advanced air mobility bill. That's really what this is about, but what they're talking about is these eVTOL vehicles. They're electric vehicles. They're basically drones on steroids, but they act as transportations, personal transportation. They take off and land or are based out of airports, small municipal airports, and they're like taxis that are electric vehicles, but they're drones and they fly you everywhere. What this bill did is basically said that the Department of Transportation needs to come up with some model ordinances and model regulations for those jurisdictions that have airports that we can use, because these things are going to be a reality in a couple of years. And they're going to start flying. In fact, in St. George, we already have people producing these down where we are and testing them between St. George and Vegas. So it'll be interesting to see how quickly this develops, but hopefully we get some model order. How many of you guys have an airport that you deal with? A few of us, yeah. So we'll see what the model ordinances come up with. Okay, B is for bonding. Those of you that are elected know that when you get elected, you have to post a bond to make sure that if you engage in criminal conduct or misfeasance, malfeasance, that somebody can collect against the bond for that activity. This bill basically changes it because most of us actually don't have bonds. We have insurance through the trust or through USIP, and this bill allows that and basically says that's what you should have as the insurance, not necessarily the bonds. So the days of the bonds are gone. Woohoo! Because, nobody even knows if there is one. C is for critical infrastructure. That's what Utah decided to call sand and gravel operations. They're critical infrastructure because we need them to build roads and subdivisions and everything else. Some of you may remember, I think it was, if memory serves, it was 2020. In the 2020 general session, right before COVID, there was a bill passed. They were trying to expand these sand and gravel operations. The fights were at like Point of the Mountain and some of these other locations. And the mining companies or the operators wanted to be able to expand without getting new permits. So if you had a permit for this parcel of land and you were mining this parcel of land for sand and gravel, and you also owned the parcel next door, they could just automatically go in there. Well, the land use people, we fought back. We were able to come up with a stalemate. Logan Wild was in the legislature back then. We came up with a bill that sort of put everything on hold, status quo, nobody expands, nobody can grow, everybody says the same, and then COVID hit and we never fixed it. The idea was, we would come back the next year. This year they came back and they kind of sort of fixed it, at least the status quo is gone. And this does allow sand and gravel operations to expand into neighboring property if they own it before the bill takes effect on May 7th of this year. If they own the land, then they can automatically expand and grow their operation, and they do not have to come in for any kind of land use application. So yeah, that's a great one for local jurisdictions, because you're going to have these huge mining operations that get bigger and bigger and bigger. But they can't go out and acquire more property now. They have to acquire it all before, next week or 2 weeks from now. I can't say this is a great bill, and hopefully it does get amended, but that's where we are right now. Okay, I like this one. D is for disclosure. This requires the Lieutenant Governor's office to amend their financial disclosure website so that you can search. If I want to pick, let's see, Eric, I'm going to pick on you. If I want to search and see all of the people that Eric Clark gave campaign contributions to, I can look it up by his name. I can say, okay, who's Eric giving money to? And I can look that up and see all the organizations and people that he's contributed to. They don't have that ability now. This makes them have to do it. And we're on elections. And some of these are going to be, they're not just minor changes. As you know, some of them are big, like House Bill 300 changed the vote by mail system so that by 2029, it's an opt-in. It's not automatic vote by mail. You have to opt into that if you want to mail the ballot. But House Bill 27 allows counties to create non-contiguous voting districts. Okay, maybe that's helpful. House Bill 109, does anybody know who fired their manager and changed the rules? Because this is clearly one of those anecdote bills that says a city council in a lame duck session, meaning from the election day to when they take office, can't change the rules on how to fire a city manager. It's so specific. Anybody know the story behind that one? No? Grandma changes because, again, I think it was Phil Lyman's campaign kept making grandma requests of everybody to get all the voter records. And they were denied. There were some appeals to the State Records Committee. This clarifies that if there's a video of the counting process, that's a public record, but the actual ballots and the voter information is private. There's another bill that we'll talk about in the grandma section that goes with this one. The tie breaking. Last year there was a bill passed that said in the event of a tie between two people, here's how you break the tie. It's still a game of chance. But this year they added it to say, okay, well, that counts for three-way ties too, because apparently there was a three-way tie and nobody knew how to break the tie. House Bill 481. This is one of those retaliation bills I was talking about. This changes how a proposed constitutional amendment is published. You guys may remember in the League of Women Voters case, the legislature they drafted this constitutional amendment, but they didn't publish it in the newspaper like they were supposed to, and the Supreme Court smacked it down and said any votes cast for that in the last election, in the 2024 election, don't count because it wasn't properly noticed. So this bill says, okay, the noticing is now not through newspaper publication, the noticing is now on the Utah Public Notice website, but it only goes if the constitutional amendment, which is House Joint Resolution 10, passes, so that's going to be on the ballot. Conflict of interest disclosures have changed a little bit. If you're running for office, you must file one at the time you file for candidacy. It used to be you filed it later. Now you have to do it at the time. And what's required, the required information has changed a little bit. So if you're representing municipalities, we've got a campaign filing season coming up in June. Make sure that your forms are up to date so that when candidates come in to file for office, they're filling out the correct information under this bill. And this is another, House Bill 551 was another one, like, who did this? What's the story behind it? But apparently there was an official that used public funds to put their name or their face on a billboard. I don't know who it was, but this prohibits it. So you can't use public money to put your name or face on a billboard if you're an elected official. Anybody know what the story is? See, I don't get the dirt anymore now, being down in St. George. Senate Bill 53 is just about removing names from petitions. This may come up in, I read in the Salt Lake Tribune today that apparently the folks protesting the anti-union bill filed enough signatures, or have submitted all their signatures. They were due Wednesday, and now they're going through to verify them. And this process in Senate Bill 53, if people want to remove their names from that, then this is a new process to do with it. Senate Bill 54 deals with people that go by nicknames or short names. If your name's Michael and you want to be Mike on the ballot, or if you want to be John Frugal Dougal and have a nickname, this tells you how to do it. Senate Bill 73 requires a statewide initiative to be published in the same manner as the constitutional amendments. So we'll see how that works and whether or not that amendment changes. And Senate Bill 18 requires state higher ed to allow the use of their facilities by political parties. So apparently there was a political party that wanted to use some place at a university and they wouldn't let them. So there you go, there's a bill. Last but not least, county clerks have to coordinate with the U.S. Post Office in receiving the bills on time. Again, this was I think it was an Iron County issue, if there's anybody from Iron County, about not counting ballots, because in Iron County they go to Vegas first and then they have to come back, and they weren't postmarked in time, so they didn't count. Again, I think it was a Phil Lyman challenge. Senate Bill 90, those of you running for an elected attorney position, county attorneys, district attorney, attorney general, at the time of filing, you must prove that you're qualified for the job, that you actually have a bar license. Have a certificate of good standing when you file for office. And then the Senate Joint Resolution 2 is another proposed constitutional amendment that says you have to have a 60% majority for statewide initiatives, not just a regular majority. And so, Joint Resolution 7, Senate Joint Resolution 7 says that only states can regulate state and local elections, not the feds. Now, that's the rule anyway. I don't know why they do this, but there you go. All right, F. F is for flags and fluoride. Most of you know that there was the controversial flag bill, so that now governmental entities are not permitted to fly, well, the rainbow flag, basically. That's what it was aimed at. And then House Bill 81 prohibited the addition of fluoride in a public water system. But what they did do is they said you can get a prescription for fluoride from your pharmacist. You don't have to go to a doctor. The pharmacist can now prescribe fluoride if you want to get fluoride. So, and we'll talk about that a little later as well. All right, here's the grandma bill. Again, House Bill 69 goes with the other one we talked about, that classifies voter records as private. And the big one, Senate Bill 277, got rid of the State Records Committee. So Todd, Sharon, he's probably not here. He just got fired from the State Records Committee. But the State Records Committee is still going to be in place until they have a new ALJ. So even though this bill takes effect, I think, May 7th, chances are good you still might have to go to the State Records Committee for a while until they get it all organized and hired. Anybody like this? Hate this? Anybody been to the State Records Committee? It's wonderful, huh? It will be nice. If you've been to the State Records Committee, you'll understand that it'll be nice to have somebody that actually understands the law, what grandma really says, and can apply it sort of uniformly. That will be a very nice thing for those of us that have been there. Senate Bill 169 on the governmental immunity. All this does is that if you have an entity that may get sued, which really is only the political subdivision, right? But for whatever reason, if you have a DBA for your organization, for example, if St. George City has a municipal building authority or a neighborhood redevelopment agency or whatever it is, we have to register those names too with the registered agent with the Division of Corporations. So as it stands already, all the political subdivisions have to register, but now our DBAs, even though they really can't be sued, we still have to register them. So there you go. I like this one. We now have official holy days in the state of Utah. These are not state holidays, but they are recognized holy days. There is a list of holy days, and I tried to practice how to pronounce some of them. Right. So you've got Easter Sunday is now also a state holiday under this bill. But it's not recognized on a Friday or Monday. It's only recognized on the Sunday. So if you've got, police officers or somebody that have to work on Sundays, that is now a state holiday. But that's the only one that was added. But these other holy days, Good Friday, Eid al-Fitr, Passover, Vesak Day, Rosh Hashanah, Yom Kippur, Diwali, some of these others are recognized as holy days, and state employees are allowed to take time off to celebrate those. I is for Ireland. We now have a Utah-Ireland Trade Commission. Woohoo! It's like, okay, maybe we'll have our own tariffs, who knows? J is for judiciary and judicial standing. So as I talked a little bit earlier about, there were a lot of bills aimed at the judiciary and the courts. The one that did pass, Senate Bill 296, did pass. It's the one that would allow the governor to name and appoint the Chief Justice of the Utah Supreme Court. That's why I have a picture of Justice Durant, Chief Justice Durant. But that was vetoed by the governor. So at this point, none of that effort was successful. I can't say that it won't be back, but it probably will. Senate Bill 203 addresses a weird series of cases. Some of you may have read last year, there were about three or four Supreme Court cases that came out last year that addressed standing. And it sort of knocked the traditional standing test on its head, and seemed to say that really, unless there's some sort of statutory standing, you can't bring a case. They were really weird. And they were just really weird is all I can say. This statute seems to address that, this bill. And so it basically brings back the regular traditional standing test for federal court and for state court. And because now it's adopted as a law, it's statutory standing. So we can comply with what the court's rulings are. But if anybody understands what that is, basically, I'm glad they did this. Let's just put it that way. I'm glad they did this because nobody really understood who could sue and be sued under those cases last year. Okay, K is for Kings. I couldn't really think of a good one to bring this one in on, but I needed something for K, so here you go. This is under the Constitutional Sovereignty Act. This is the act that was passed either last year or the year before, I think. That basically said the 10th Amendment rules and we are sovereign and federal government, you can't tell us what to do because, the Utah legislature in their schizophrenic way likes to say feds butt out, but then they like to also, they like the idea of federalism, they support federalism, federal government stay out, but oh, by the way, we're gonna tell local governments what to do. They sort of don't see the hypocrisy there. But this one amends the Constitutional Sovereignty Act so that school employees are now also considered government officers. And what that act does is basically say government officers can't enforce federal law if it's contrary to the state, what the state wants, basically, in the state law. So interesting, but has to do with some of the immigration stuff. We'll see how this one plays out. But now it involves the schools as well. All right, land use and housing, I sort of grouped those all together in those 25 bills. I'm not gonna hit all of them. Most of them are in your packets. I'm gonna sort of hit the highlights. I could spend 2 hours just on this stuff. We'll go through it really, really quickly. In the building permit, building world, there were three that were really, you probably want to take note of. HB 58 addressed building inspectors and building officials. It now has requirements. If you're going to name somebody as a building official for your city or for your county as the chief building official, they now have statutory requirements they have to meet that includes like 6 years of experience and qualifications and yada, yada, yada. So they have to do that. And so you want to make sure that, obviously your folks are compliant. House Bill 435 was a bill passed by Mike Kohler, who's out of Wasatch County. And this one basically says if you're building what's called a quote unquote high tunnel, anybody know what that is? It's basically a hay barn. It's a building that's used to cover agricultural materials, whether that's being stored or grown or whatever. They're called high tunnels. And these no longer require a building permit. And so they're exempted out from the building permit requirement. And then House Bill 550 basically says you cannot charge a water conservation district any building permit fees. So there you go. Eric, doesn't your office represent a water conservation district? They have their own attorneys, yeah. So in the signage world, there were a couple of sign bills. One was pretty minor, but this one is the billboard bill that basically, this is the fight about if you require a billboard to move because you're putting in a highway or relocating the highway or whatever, and you're triggering a move, the move has to be within the same city. You can't move a billboard into a different city if it's being moved. And then housing, there were three bills that I think are really important. House Bill 37 basically allows jurisdictions to give incentive density programs for affordable housing. That's a good one. Senate Bill 181, really pay attention to if you're in this world. This one focuses on affordable housing and things that jurisdictions need to do to make housing more affordable. One of the things that's in there, they define what affordable housing is finally. So when you use that term, it means housing that meets 80% of area median income or below. But it also defines how big your parking spaces can be for a house. So it says that if you have a covered parking space, it can only be 10 by 20, and you can't require that it be any bigger than that. That's for your garages. For your driveway spaces, the uncovered parking, you can only mandate 9 by 20 spaces. So St. George, our city council was really mad because big trucks with long beds and trailer hitches were hanging over into the sidewalks and it was interfering with people. So they passed an ordinance that said all driveways must be 25 feet. Well, guess what this bill does? Just wipes out that St. George ordinance. So driveways can only now have to be 20 feet. Senate Bill 262, again, recognizes that consent agreements are legitimate settlements of lawsuits and that you can do them and that they're legal and you don't have to go through the Planning Commission. They can just be settled by the legislative body. Okay, the big land use bill this year was House Bill 368. It covers a lot of stuff. I've sort of focused on some of those things. They came up with a ministerial land use regulation, which is a total oxymoron and I think is probably unconstitutional. I don't know that that one's gonna survive. They changed how annexations are done. They've changed how you change municipal boundaries. That addresses the identical plans. So if you come in, if you're a home builder an Ivory Homes and you've got Plan A, B, and C, and Plan A, B, and C have already been approved by that jurisdiction and other developments, you don't have to go through a plans review. And there's a very simplified plan review for those kind of plans if they're identical. Plan review, private maintenance of public assets. We can't require private HOAs or other folks to maintain our public assets. Prohibits public hearings for variances and appeals. I don't know who was doing that, but that's a good thing, because public hearings for those are really bad ideas. And then on the last one, it modifies the fire code for the road standards. So it used to be that, subdivisions required that you had curb, gutter, sidewalk, pavement. That's part of the essential infrastructure for a subdivision before you can start selling off lots. This changes that so that as long as you meet fire code, and fire code requires an all-weather surface, it doesn't require paving. So now you can start building your subdivision with a graveled road, not a paved road, but eventually you have to do the paving. It's weird. And I don't know, again, I don't know the story behind this one, but that changed. Some of the other stuff is, the good news is we can now enforce short-term rentals again by looking at the Airbnb websites and the VRBO websites. We can start doing that enforcement again. We got that ability back. There's a modification to how you subdivide ag lands and whether or not it's a subdivision in House Bill 255. Boundary adjustments. The surveyors of the world got together and passed this bill, Senate Bill 104, and it's really bad. But essentially what it says is you can change lot lines or change property boundaries by agreement. That's fine. And you do still have to get the local land use authority's approval, but you can do it without amending plats. Now that's the bad part, because that really screws up your county recorders and your county assessors. So most jurisdictions are still going to require a plat amendment. And the law says that if the local jurisdiction requires a plat amendment, you still have to do that. But this is a really weird, bill, and it does things that I think the county recorders are going to have a really hard time with, and the county assessors. And then Senate Bill 179 requires a land use regulation or a land use authority to review business license uses. And it requires that you set up this process why, okay, if there's a use for a business license, it gets reviewed by the planning department. Okay, M is for massage. I put that on there because I'm a firm believer in my every other week, hour-and-a-half massage. But this modifies the licensing requirements for massage therapists. It talks about what's unethical behavior, obviously. It requires some background checks. It beefs up basically the massage licensing so that it's more therapeutic, less fluffy, more therapeutic. Nonprofit, government nonprofits, there were a couple of tweaks. One of them was that they excluded the Utah Association of Special Districts as a governmental nonprofit corporation. I don't know why, but they did. And it does require a governmental nonprofit. UAC would be a governmental nonprofit. The League of Cities and Towns is a governmental nonprofit. And it requires them to post financial information, just like any other governmental entity, on the Utah Public Finance website. O is for OSHA violations. They upped the fine for each serious violation. There you go. Anybody like OSHA? They're so much fun. Privacy. So there was a privacy person, privacy czar, I don't know what we called them before, that worked for the state auditor that adopted all these privacy laws, right? That we have to now comply with in terms of when we have personal information, how we do that. We have to make sure we have training. We have to make sure that we keep that information private if we have utilities and there's account information, that kind of thing. It turns the privacy czar into the privacy auditor, grants that person more authority to do audits and to sort of enforce against agencies that aren't compliant with the new privacy rules. So make sure that you're compliant and working on getting compliant with the privacy rules. Okay. Q is for qualified jurors. There was this House Bill 49 passed this year that said convicted felons can't serve on juries. Now, some of you may say, well, that's logical, right? That seems fair. But remember, in Utah, felons can still vote, so they could still serve on juries, and this says now they can't. Unless it's been expunged, obviously. Okay, R is for roads. There were only 3 road bills. They're really housekeeping bills, removing and adding state roads, or modifying the descriptions of state roads. House Bill 103 now requires that the Public Lands Office and SITLA both have to identify all the public roads that cross their property. And they have to take that and record that with the county, just like we would all our class A, B, C, D roads. And the other thing is they cannot close a road without the consent of the county legislative body. So this one's a good one, I think, probably just because it identifies what are going to be the public roads across those public lands. House Bill 345 just described the highway access for the new, for Lost Creek State Park and Utah Raptor State Park. I like this one. Spaceports. Senate Bill 62 created an exploratory committee for spaceports to look at the space launch services for satellites, scientific missions, defense missions, commercial space flights, space exploration, cargo transport, and space tourism. They appropriated $1 million for this. The picture on that looks like a horseshoe, that weird building, is actually a spaceport in Las Cruces, New Mexico. And of course, then I have Katy Perry and her recent space tourism flight. So we are looking at that for the state of Utah. All right, tax bills. Property tax was a big one. There were several bills on this. The school district mill levy now has some oversight by the State Tax Commission and the Governor's Office of Planning and Budget, which is a really interesting thing, because usually school districts can just levy a mill like everybody else. They do the truth in taxation and they do their mill levy just like the rest of the governmental entities, but they now have some oversight. Senate Bill 197 was vetoed. This is a bill that changed the way senior citizens get some tax relief. This is the bill that allows for some tax abatements if you have under a certain income, if you're over 65. They wanted to change that and take away the abatement and make it deferred. So the tax would remain, but it would just be deferred until you sell your house or die. And then it would still be charged against the house. That one was vetoed by the governor. So that status quo remains. Senate Bill 202 requires counties to report their assessments to the State Tax Commission and gives that commission authority over non-compliant counties. So again, counties now have to report their tax base, their tax assessments to the State Tax Commission. And it also removes the newspaper notification for tax increases or truth in taxation. But it requires that if you're going to have a truth in taxation hearing, you have to allow online participation. So if anybody's doing a truth in taxation hearing, just know you have to allow online participation at that public hearing. Senate Bill 295 reduces, this is a weird one and I hope I understand it correctly. If you reduce your budget to below what the previous year's budget is in order to increase revenues, it allows you to increase revenues without doing a truth in taxation hearing. Not exactly sure how that works, but if anybody understands this one better than me, please speak up. I'm hearing crickets, you're all asleep by now. Okay. Some other tax bills that came out in different categories, sales and use tax. Senate Bill 40 is just housekeeping. It changes the grace period for certified sellers before they have to start reporting their sales tax. Senate Bill 47 removes the sales tax for personal property and electronic transfers of goods. Senate Bill 213 exempts energy storage manufacturers from sales tax. I don't know if this has an impact on anybody. It didn't necessarily affect me or my entity, so, I figure I'd throw it out there. How's that? The truth in taxation hearing requirements clarifies that you do have to have a quorum of your elected officials present during the truth in taxation hearing. I didn't even know you could do this, but apparently there were jurisdictions that were having the truth in taxation hearing and just sending staff to do the hearing and not attending. The elected officials were not attending. There wasn't a quorum of the legislative body attending. This clarifies that no, they have to show up. Income tax. Extends the income tax credit review cycle from 3 to 5 years, and then the Social Security tax, this is the one that increases the amount of money you can make, that you get that credit for your Social Security income. The transient room tax, there were a couple of bills. House Bill 456 clarifies and modifies what that money can be used for by counties. And it's similar, but they've sort of tweaked some of the definitions and clarified some of that. So if you're representing a county that's using those funds, make sure that you take a look at that you're compliant. And then Senate Bill 261, this is more reporting and oversight by the state, right? And that federalism, hypocrisy. So the counties now have to report their use of the transient room tax to legislative and fiscal analyst, who then reports it to the Rev and Tax Committee. Now, this is because of the Grand County issue when they were found to be non-compliant with the way they were using their transient room tax. But now you've got some legislative oversight of that, but all counties have to comply. And last but not least, Senate Bill 91 imposes the 1% county tax for restaurant taxes on, gas station food, basically. Okay, here's the union bill. This was a picture out of the Salt Lake Tribune. I think it's the Unified Firefighters that showed up at the Capitol. But House Bill 267 is the one that prohibits a public employer from recognizing unions or engaging in collective bargaining. This goes in effect on May 7th. And I just read in the Tribune today that Salt Lake City just did a new collective bargaining deal with their unions. I think they have 3 unions in the city. And they just did it before this bill takes effect, and they're prohibited from collective bargaining. So they just inked new deals. The interesting thing for me on this bill was, you sort of had all these people lose their minds about the fact that they said no unions. But the reality is, governmental entities have never had to recognize unions if we don't want to. It's always been optional. You could if you wanted to, but we don't have to. And that comes from a case way back in 1978. I put the case up there, the Wesley case versus Board of County Commissioners of Salt Lake. And the Supreme Court basically said, because we have merit systems and because we have legislative protections in place for public employees, that governmental entities do not have to recognize unions if you don't want to. And it doesn't matter how many members of your staff vote to unionize. It doesn't matter. You don't have to recognize them, and you don't have to collectively bargain. But if you wanted to recognize them, then you could, and Salt Lake City obviously has done that. This bill prohibits it flat out. But this is also the bill that is going to probably be subject to a referendum if the signatures that they submitted on Wednesday are sufficient and if they get enough votes. But it may be, because this is a statewide referendum, it may be that they need the 60%. Who knows? I don't know what the rules are going to be on this one, but it'll be interesting to watch. Senate Bill 327 reiterates again that private employees still retain the right to collectively bargain and unionize if they want to. Okay, we're almost done. V is for vaccine. They designated any kind of vaccine that's contained in a food product as a drug. All I could think about is when we used to get, for those of us that are really old, that the polio vaccines were given in sugar cubes. I don't know if that's what they were trying to address. That's what the picture's of, is when you got your polio vaccine, it was in a sugar cube. But this basically says if you're going to put a vaccine in a food product, then it's counted as a drug and has to be regulated like a drug. Okay, water bills, these, nothing really significant. Water has been a big deal, and we in the South still don't have enough water, but these are really just housekeeping bills. You've got water quality and dealing with water applications, what happens if you transfer water in probate, some grazing and watering on public lands bills. House Bill 274 deals with water rates and setting the water rates that may or may not apply. And Senate Bill 80, DEQ can establish some fees for water quality, but there are some exceptions for again, water districts that probably don't have to pay those fees. Okay, X is for the RX. And again, this is the pharmacy bill that goes with the fluoride bill, because pharmacists now are allowed to prescribe fluoride. This bill then changes the way we treat pharmacists and allows them to be a healthcare provider that can prescribe things. So they sort of worked in tandem because we're allowing pharmacists to actually write prescriptions for fluoride. Okay, Y is for youth services. How many of you guys, your jurisdictions, operate any kind of Little League sports or youth programs? Raise your hands, anybody? Okay, this will apply to you most likely. What it basically does is says, because you really should run anybody, if you've got employees or volunteers that are working with your youth, you need to run them through a criminal background check, including all the sex offender registries. Therefore, you can require that they give you their full name and ID so that we can run that information. Obviously, if you're an employee, we're gonna have that. If you're a registered volunteer, we're gonna have that, but this allows us to require that. And you probably should do it, is all I can say. Yeah?
I thought it was required, and the penalty if you don't run the names of employees and volunteers, you lose, there's an automatic presumption that you're negligent.
Correct. So if you heard that, running the background check is required. What this bill does is says we may ask for the full name and ID of the employees in order to run that background check. Makes no sense if the background check's required anyway. But he's right. If you fail to run the background checks on these people working with children, then you lose that presumption that you're not negligent. So it's really important to do that. Okay, last but not least, Z is for the bzz of bees. This one cracked me up, so I had to put it in there somewhere. It now creates a veterinary client-patient relationship with bees. Please, somebody tell me, for the love of all that's holy, why? I don't know, but that's what the bill does. It establishes a veterinary client-patient relationship. So there you go. We will see what next year brings, but hopefully I'm even early a little bit, just a little bit. But thank you very much for inviting me back. Hopefully you weren't too bored, and we'll maybe see you again next year.